Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 333542. Case is filed with State of Texas versus Kayana T. Hornich. Ms. Hornich, would you please raise your right hand? Ms. Hornich, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
That's right.
Ms. Hornich, you may put your hand down. How are you doing, Ms. Hornich?
I'm good. How are you?
I'm doing fine. Thanks for asking. Now, Ms. Hornich, your case has been set for an arraignment, and what the arraignment is an opportunity to for the court to inform you as to what you've been charged with, what your rights are, and what your options are concerning your case. Now, your case is a theft case. This is a Class B misdemeanor. The range of punishment for a Class B misdemeanor is a minimum of 0 days to a maximum of 180 days in the county jail, which is 6 months, or you could be given a fine from $0 to $2,000, or you could be given both such fine and confinement. Do you understand that?
Yes, sir.
Now, as a defendant in a criminal case, you have a right to have an attorney. Now, you just filled out a document that is titled Judge's Explanation of Rights to Have an Attorney. And this document states that as a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request an attorney to be appointed to represent you. And number 3, you may represent yourself. And this document further states that if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you wanted to represent yourself, that means if you wanted to waive your right to an attorney, you may not speak to a prosecutor. We have 2 prosecutors in court. The prosecutors work for the district attorney's office. And now you can't speak to a prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. What a waiver is, you're giving up your right to have an attorney. You'll be waiving your right. Do you understand that? Now, be aware that there are dangers to self-representation. Waiving your right to an attorney representing yourself may result in the worst outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request an attorney from the court. Now, on this document, it says defendant's choice, mark initials next to only one choice. If you wanted to apply for a court-appointed attorney, you put your initials on the line number 1 that says, I want to reset this case to hire my own attorney. If you've already hired an attorney, then you put your initials on line number 2 that states, I have hired an attorney whose name is, and you write the name of the attorney in the line to the right. Now, your initials are on the line that says, I want to apply for a court-appointed attorney. And now, before you sign this document, did you read the document?
Yes.
And did you understand what you read? And is everything in this document true and correct to the best of your knowledge?
Yes.
And is this your signature on the line that's titled defendant? And are these your initials on the line stating that you would like to apply
Yes.
for a court-appointed attorney? Okay. Now, also, Ms. Hornich, as a defendant in a criminal case, you have a right to have a trial by jury, which means that you have a right to have 6 citizens from the Jefferson County to be selected as jurors in your case, and they will decide whether or not you're guilty or innocent after listening to all the evidence in the case. You also have a right to waive or give up your right to have a trial by jury. And by doing so, your case still will come before the judge in one of 3 ways. It could come before the judge by way of a bench trial. That is, a trial before the judge only. The judge will listen to the evidence and the judge will decide whether or not you're guilty or not guilty after listening to all the evidence. You can waive or give up your right to have a bench trial as well. If you do, then that means that you're telling the court that you would like to enter a plea of either guilty or no contest to this case. Now, just to bear in mind, you can enter one of three pleas. You can enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be contesting or you will not be fighting those charges. Now, if you enter a plea of guilty and no contest, and if you waive your right to a jury trial and a bench trial, then your case will come before the judge by way of a plea bargain. The plea bargain can be an agreed plea bargain. What a plea bargain is, that's an agreement that you have worked out with the state or with the district attorneys to settle your case. And your case will come before the court. The court does not have to follow the plea bargain agreement. If the court does not follow the plea bargain agreement, you will be entitled to withdraw or take back your plea. Do you understand that? Now, if the court follows the plea bargain agreement, and if you decide within 30 days that you would like to appeal your case, that is, you would like to have a higher court to review your case to determine whether or not you have been wrongfully convicted or whether or not this court has committed an error by convicting you, then you have to get my permission to appeal. Do you understand that? Now, you also have a right to enter what is called an unagreed plea bargain. What an unagreed plea bargain means is that you and the state have not been able to reach an agreement concerning the punishment in your case. And you want the court or the judge to decide what the punishment will be. The punishment, as I mentioned earlier, will be anywhere within that punishment range. The punishment range from 0 days to 180 days, a fine from $0 to $2,000 or both such fine and confinement, and you may be eligible for what we call probation. There are two types of probation. One type of probation is what we call regular probation. The other type of probation is called unadjudicated or deferred probation. The difference between the two is that with the deferred probation, it does not result in a conviction on your record. And if you successfully complete it, you may qualify for what is called a non-disclosure. And that means that the court cannot disclose that fact that you were on probation to the general public. However, there are some exceptions to the rule that some agencies will be able to have access to that information. But by and large, most companies, most of the general public will not have access to the fact that you were on deferred probation for that case. Do you understand? Now, if you get regular probation, with the regular probation, it does result in a conviction on your record. However, there's something that's called judicial immunity, where the judge can set aside the conviction. And if you successfully complete the probation, and if you don't have any more time left on the probation, then the court can set aside the conviction, which means you will not have a conviction on your record. However, if you later on commit another offense, then this case can be revived, resurrected, or brought back up and used against you. Do you understand that?
Yes.
All right. Now, you also have a right to have witnesses to come to court. What that means, you have a right to have people to come to court to testify for you or against you. If you're represented by an attorney or if you're representing yourself, questions can be asked of that witness. That's either called direct examination or cross-examination. And you have a right to waive or give up your right to have witnesses to come to court. That simply means that you would not be calling witnesses. However, it does not mean that the state will not be calling witnesses, because the state will be calling witnesses in their case. Now, you also have a right, it's called a Fifth Amendment right against self-incrimination, which means you have a right not to testify in your case if you decide to. The state or the district attorney's office cannot force you to testify against yourself in your case. However, if you waive or give up your right, your Fifth Amendment right to self-incrimination, then you will be testifying in your case. Do you understand that? Now, you also have a right to have discovery. Discovery means you have a right to see the evidence that the state has against you. You have a right to see the documents, videos, witness statements, audio recordings, instruments, whatever evidence that they have that they will be using against you in your case. you have a right to have access to that. If you're represented by an attorney, your attorney will be having access to that. Now, if you are representing yourself, you will be having access to it. Now, also, you should bear in mind that you're here today because you're out on bond, either out on a PR bond, surety bond, or a cash bond. Cash bond, it means you paid the full amount to get out. Surety bond means you paid a percentage of the bond to get out. And a PR bond means that you release without having to pay any money. You was released on what is called your own personal recognizance, promising to appear before court. Now, every day that you spent in jail can be used as credit towards your punishment. So, for example, if you spent 5 days in jail and the state is off, you and the state has worked out a plea bargain agreement for you to serve 5 days in jail, you will not have to serve any more time in jail. Why? Because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you have already served. Now, if they're offering 7 days and you serve 5 days, that means that you would only have to serve 2 days, because we're going to take 5 from the 7 and it leaves 2. Now, if they're offering a fine and court costs in your case, every day that you spent in jail, you get credit at $100 a day toward your fine and court costs. So, for example, if you spent 5 days in jail, that's $500 that can go toward your fine and court costs. Now, if the state is offering you fine and court costs of $500, you would not have to pay anything. Why? Because you spent 5 days in jail. 5 days in jail is equivalent to $500 that will go toward your fine and court costs, and so you would not have to pay anything, because you've already paid it off by serving time in the jail. So therefore, the fine and court costs will be taxed and retired. Now, if they're offering fine and court costs $700, you spent 5 days in jail, you got $500 credit that goes toward the $700. That means you would have to pay $200. Do you understand that?
Mhm.
Now, if you cannot pay the fine and court costs on the day that your case is disposed of, then we can put you on what is called a payment plan. So you can pay it off over a period of time. Now, even if you're not working and you still cannot pay it off, then we can convert your fine and court costs to community service, which means you will work at a nonprofit organization in our community, and every hour of community service that you will do or that you perform, $12.50 will go toward your payment of your fine and court costs. So, for example, if you work 8 hours one day, then $100 will go toward your fine and court costs. Do you understand that? Now, Jefferson County has a program that is called pretrial diversion. With pretrial diversion, if you qualify for that program, the case will be dismissed. Right? You'll get into the program, case is dismissed, and you may qualify for an expunction. And what an expunction is, it means that this charge can be erased, deleted, or wiped off of your criminal history. Do you understand that?
Yes.
Now, you would have, in order to qualify for that program, it cannot be an offense involving resisting arrest, unlawfully carrying a weapon. You have to get an attorney to assist you at getting in that program. And this has to be the first time that you've been in trouble. So you cannot have a long criminal history, is what I'm saying. Do you understand that?
Yes.
Now, if you think you may be interested in that program, you can talk to one of the prosecutors. They can give you the paperwork, or if you get an attorney, the attorney can make an application to see if you may qualify for that program. Do you understand? All right. Now, this court has a program that is called a CSI program. Part of that program, we have partnerships with agencies in our community. One of the agencies we have a partnership with is Spindletop. And Spindletop, they're a local mental health agency. They will do a private screening, an assessment, and screening and assessment, and a treatment plan. Also, they have a program that is called ATAR. ATAR means that if a person is having problems with drugs or alcohol, then a person can, they have a program where they can do a private screening, they can do an assessment, and they can develop a treatment plan, either outpatient or inpatient as well. Now, they also, we have a partnership with Lamar University. Well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. That stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once individuals select the area that they would like to be trained in, once they are trained in that area, Lamar University will assist them through their CICE program. They will assist them at getting the job in the area that they're trained in. Now, if a person does not have a high school diploma, then Lamar University has a GED program where you could get your high school equivalency diploma. And all of these programs that I have just mentioned are free, does not cost you anything. Only thing you have to do is have a desire to participate in any one of the programs. Now, this is a program that I started in March of 2017, within 100 days of taking office. And this program is designed to address the issue of what we call recidivism. Recidivism means when people commit crimes over and over. And so we address it by our CSI program, stands for Community Safety Initiative, which is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children. And with this program, we don't do, in County Court Law number 2, we don't have court as usual, we have unusual court, and that simply means that we're not different. It just means that we're trying to make a difference in the lives of the individuals that comes before the court, and we're trying to make a difference in our community, the community in which we live. And in this court, we do not just give time, we take our time, because we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people, we believe that productive people will not commit crimes. Why? Because they have too much to lose. All right. So if you're interested in that program, just please feel free to let us know. Now, I do have before me a document that is an affidavit of indigence. And with this affidavit of indigence, now, we swore you in?
Yes.
Okay. Now, in this document, Jefferson County Affidavit of Indigence, do you recognize this document?
Yes.
And on page 2 of this document, there's a signature above the line that is titled Defender Signature. Is that your signature?
Yes, sir.
And I've read your answer. Now, let me do this here. Based on your answers in the affidavit of indigence and the judge's explanation of rights of defendants without his attorney. Now, prior to signing and initialing these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay. Ms. Hornage, I read your answers in these documents. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that is appointed to represent you in this case is Attorney Jack Lawrence. Okay. Now, Ms. Hornish, Mr. Lawrence is going to be given information on how to contact you. You will be also given information on how to contact him. Our court coordinator is going to give you that information. Here you go. Once you get that information from our court coordinator,